Hi, everyone. This is Kayla Marty with McGuireWoods, and welcome to our webinar for today, which is Key Transaction and Regulatory Consideration for Women's Health and Fertility. Before we get started, I wanted to just take care of a couple of housekeeping matters. I see that everyone looks like they're being able to join fairly easily, but I also wanted to direct your attention to the Q&A box that will be on your screen if you're participating through On24. In this box, you can easily ask questions to anything that we're talking about during the presentation. We will try to address those questions as they come up in each of the topic areas. But if for some reason we don't get to your question during the presentation today, we will separately reach out to you after the presentation. And please don't hesitate at any time to reach out to either Erin or I to talk about anything that we discuss on the presentation today. So with that, thank you so much for joining us. My name is Kayla Marty. Like I said, I sit in McGuireWoods' Charlotte office. And many of you on the phone, I know, are familiar with McGuireWoods and our Charlotte office, but McGuireWoods is a large law firm. We have 24 offices with more than 1,000 attorneys, but of our attorneys, about 60 focus specifically in healthcare. And we have a specific niche that also focuses here in women's health, which is the genesis of this discussion. We hope you find it useful, and I'll let Erin introduce herself now as well.
Thanks, Kayla. Hi, everyone. My name is Erin Dine. I am an attorney in the Chicago office of McGuireWoods. Like Kayla, focus my practice on healthcare transactions and the corporate side of things, also touching on the regulatory side of things, and have been active in the women's health industry. So Kayla, with that, I think we're ready to progress through the presentation.
Great, thank you. So here is a brief slide that talks about the various items that we're going to discuss today. So first on the agenda will be a brief market overview and flagging some recent transactions that have happened. I know many of you are aware that this space has been very hot, both in the private equity and in the strategic space. Fertility is very deconsolidated, which we'll talk about a little bit, and also has some very attractive ancillaries. And then on the OB side, it's still very deconsolidated, but it does have a few groups throughout the country that are a little larger in size that have been very active. So we'll talk a little bit about the reasons why the market has been really attractive, being payer certainty, certain state mandates that have come out over coverage, and then also on the fertility side, at least, a pretty low number of dollars coming in from government pay. Then we'll talk a little bit about the transaction process. Women's health transactions follow very similar processes that we see in the other physician practice space, but there are some nuances to consider, particularly on the diligence front. The regulatory concerns for both OB and fertility are very unique, a lot of it being driven by the fact that it is not heavy Medicare, and then on the fertility side, not heavy government pay at all. So we'll flag a couple of fraud and abuse statutes and regulations that you should be particularly aware of, and then also some state level statutes that are of interest. HIPAA is always a concern in any physician practice space, whether it be women's health, orthopedics, urology, something to consider. And there's a few specific consent issues that we'll flag related to fertility and HIPAA. Last thing on the key diligence and regulatory considerations are around compliance plans and structures. We have seen across the board, it has been very consistent that lack of compliance structures often lead to lack of compliance, which increases the overall risk of a particular practice when they're being bought in diligence and looked at in diligence. But also once you move to the integration phase, it becomes very important that there is an appropriate compliance structure to identify issues as they arise. And then we can't ignore any COVID-specific transaction considerations. Many people on this phone I know are aware, to the extent that you have large transactions, the FTC has announced close at your own risk letters directly related to COVID and the workload that they're experiencing. So we'll talk a little bit about that. And then also many people are aware of the very crowded RWI market right now, partially due to COVID, which is definitely slowing down some transactions and changing the diligence landscape a little bit for people. So we'll talk about that as well. You'll see as we flip through these slides, we've included a lot of material for you all to reference after the fact. We will probably not hit absolutely everything on the slides just since we only have an hour, but please, like I said at the beginning, feel free to come back to us, ask any questions. We're happy to talk off the clock on some of these topics if you're interested in them and would like to have a broader dialogue. So with that, let's talk a little bit about market conditions and recent transactions. I would be remiss if I didn't include a slide on Femtech. Many of you probably have seen the New York Times article that was very significant on the Femtech industry. It is not something that we heavily focus on in the transactional space for physician practice management deals, but it is something that is of a major interest to the market right now. So I've included a little bit of information here if it's of interest to you. I also wanted to note I am seeing very significant investments by various platforms and other women's health players in these Femtech companies to the extent that they aid their patients, they increase the quality of care. That's something to be aware of as you're going through transactions. I would be surprised if you don't see a number of businesses that are invested in some of these Femtech platforms. So I won't spend a long time talking about it today, but I did want to include some information here for reference because it's a piece of the industry that absolutely cannot be ignored and is very interesting, and its growth has really just exploded. So let's talk a little bit about the reasons the market has expanded so much. I'm going to talk first about fertility and then come back and talk a little bit more about the OB side of the house as well. So as many people know and has touched many of their own families from time to time, infertility issues are affecting more families across the board. More women are seeking care, specifically from IVF, which has increased the demand for fertility services across the country. It's also increased the demand for ancillary services, for egg freezing, egg banks, donor matching. Those are all things that we've really seen a huge increase in over the past 5 to 10 years. And we do expect, based on many studies that have come out, as you can see listed here, a steady increase in those revenues, in those opportunities in the market. So that's the reason we're seeing a significant amount of transaction interest in it, paired with the fact that it remains a very fragmented segment of the market. For those involved in the fertility market, you will know that the vast majority of clinics are regional. They are often serviced by 2 to 5 physicians that are then supported by a small number of staff. There are very few large fertility clinics across the country, which makes it very attractive to consolidate and try to achieve some economies of scale, particularly on the ancillary side, lab, egg banks, donor matching. Those are all things that have been very, very attractive. OB, like I said at the beginning, is also a very fragmented part of the market, but we have seen historically, and you'll see this in the next slide, on some of the major transactions that have occurred, more consolidation in that market than we have in the fertility market historically. One of the things that I've seen be very interesting in market growth associated with the OB side is the shortage of OBs in a number of markets. So you'll notice in places like Nevada, in places like Florida, there's an extreme shortage of OBs to serve many populations, which is driving both consolidation, but also organic growth, recruiting individuals into those markets to serve a need. And that's been a major focus of various health systems or health plans that have been supporting that growth. And there's a lot of opportunity there for negotiation and bundled care if people can achieve it and have the right scale to achieve it. So that's just something to note. It would be remiss if I didn't note that there are huge differences in the fertility and the OB sector. It is unusual to see those services in the same platform or within the same practice. They have very different comp models, very different work schedules, and very different ancillaries associated with them. So although McGuireWoods addresses both the women's health and the fertility practices often within the same working group, they are very different. Their payer mix is very different. So throughout the presentation, we'll make various distinctions between things that we're seeing in the OBGYN businesses versus things that we're seeing in the fertility businesses. I just wanted to note that as we go through the presentation. For reference, these are a couple of the large transactions that have been publicly announced in connection with the women's health space over the past year. As you'll see, there's some very significant consolidation that has happened and a lot of activity. So we continue to see a lot of interest here and expect it to continue in the future. Erin, do you want to give us a couple of key transaction considerations?
Of course, thanks. So as we proceed with this presentation, we did want to talk about what we're seeing in terms of a specific transaction. First, in terms of planning, and then we'll progress into the process and kind of key diligence items to look at. So from a sell-side perspective, there are many things that a seller could do to, quote, clean up shop before a transaction progresses. And we are seeing a lot of activity in our engagement as legal counsel for sellers to engage us as a specialist to conduct a pre-transaction diligence review of their practice to see if there are any major cleanup areas that should occur before a transaction. So sellers are really seeking to ensure that they use all of their resources to ensure that they know what is at their practice before a transaction progresses. In terms of COVID, another thing that sellers need to consider is to use all of their funds or have a plan to use all of their funds in connection with any and all PPP loans received. This is something that could become a barrier to closing. We want to ensure sellers are prepared for that. You'll see on this slide, we included a very broad time frame of how long a transaction could proceed. This depends on so many different factors, whether it's the size of the platform or rep and warranty insurance involvement and other kind of specialists and counsel. But typically we are seeing 60 to 120 days that the transaction will proceed in terms of that process. Now, of course, on this slide, we include some of the general categories of the transaction process, but of course, the steps of a transaction will be a little more detailed compared to what you see on this slide. Before anything confidential is shared between parties, the parties will enter into an NDA or a confidentiality agreement. It is possible, of course, that some generic information might be disclosed prior to the NDA to either entice a bidder or perhaps give more general information to a potential buyer. But in general, an NDA is required before any confidential information is shared between the parties. Further, prior to sharing any antitrust sensitive information or documents such as payer rates or payer agreements, there may be a separate clean team NDA negotiated between the parties such that a specific portion of an enterprise of either the buyer or seller will be the only individuals who will see those antitrust specific information or documents. And after the bid process or that initial review, the parties will then enter into a non-binding letter of intent. Now, the form and structure of an LOI or letter of intent really differs between parties and transactions. So typically we see counsel involved at the LOI stage, Or if the parties do not seek to involve counsel and they want to ensure that the parties are on the same page, we recommend including language in the LOI that the LOI is subjected to regulatory and legal review. And like I mentioned, we definitely see LOIs of all flavors. Sometimes an LOI can be just a very basic understanding of some material terms between the parties, or sometimes we see parties negotiate all of the material terms at the LOI stage. So it really depends. There's definitely pros and cons to each, but we're happy to advise on anything that you would like to talk about in terms of an LOI, because it really depends on the specific parties and what you seek to accomplish at that beginning structure and beginning phase. After the LOI is executed, the buyer will proceed with its due diligence process. If rep and warranty insurance is involved in the deal, the diligence review and analysis will definitely be more intense, but in general, the scope of diligence really depends on the size of the deal and what kind of deal structure will be implemented at closing. So if it's an asset deal, we typically see buyers only really focus on certain material items or where items could incur successor liability. If it's a stock deal or equity deal, the diligence scope is probably greater. However, you know, of course, if there's a platform deal and a stock deal, that diligence scope will, of course, be larger. But simultaneously with that diligence review, the parties will negotiate the transaction documents. We've also seen before the transaction documents are negotiated kind of a phase one diligence review. So depending on the size of the deal, the buyer may be interested in understanding if there are any hot diligence issues that arise. And we are often engaged to conduct kind of that first wave of diligence before any kind of transaction documents are drafted or any legal dollars are spent. After that first wave, we then proceed into that negotiation of the transaction documents, and then we'll look to complete all the closing conditions. Antitrust counsel should be also engaged, depending on the size of the deal, early on to determine if any filings are required. And your counsel will also need to determine early on if there are any pre-closing change of ownership or change of control notices or consents required in connection with the seller's licenses and contracts. Representation and warranty insurance may also be explored at this stage, and Kayla will discuss the RWI process.
Great, thank you, Erin. We wanted to include some slides here on RWI Basics because we're seeing it become very popular in the women's health space, but also very popular in the healthcare space generally. Previously, it was not as popular because we often could not get very good coverage on billing and coding issues, healthcare compliance issues, which are obviously the meat of what results in losses for many of these businesses. That has changed significantly over the past 5 years. You can now often go out to market and get pretty good coverage and also sometimes supplemental coverage on those type of losses. So it is possible to get both buyer side and or seller side coverage, but it is more common for the buyer to be the party that is engaging the RWI insurer and is having the coverage written. The advantage of RWI is it really provides an alternative to a buyer going against a seller, particularly a seller that they're going to be an ongoing partner with in the event that there's any breach of representation under the purchase agreement. And so we've seen that be a really attractive alternative, particularly in healthcare private equity backed deals where there's often a rollover component. It makes the ongoing relationship much more comfortable to have the coverage against indemnity obligations, but not have to go significantly against your partners on a go-forward basis to cover it. So as far as policy period, retention, and items that are not covered, these are some of the most common things that we are asked. Often the coverage can be up to 6 years. It's often 3 years on all reps, 6 years on tax and other negotiated fundamental reps, which in some situations can include healthcare reps, but in some situations do not, depending on the insurer. The retention amount, or sometimes people call this the deductible amount, it's typically 1% to 3% of the transaction value. we are seeing more commonly that this retention is being split between the sellers and the buyers. We do see that fairly significantly, so that could bring that number down for each of the parties. And then items that are not covered. So these are things that when you're going into the RWI process, you should not assume will be covered. So breaches that are actually known or otherwise disclosed, forward-looking statements. Covenants are usually not covered, but can be in some situations, and then pension underfunding. One other thing to note about RWI policies are, from a transaction process perspective, they almost always require a Q of E, a billing and coding audit, and a fairly fulsome legal diligence analysis. So to the extent that you'd like to pursue this coverage, it's important to know that those are elements that you should be prepared to produce in connection with diligence. This is just a visual of the risk allocation shift. So you'll see on the left-hand side of the slide, this is a traditional transaction without an insurance policy. So often this space in white is seller responsibility. On the right-hand side, the insurance policy steps in to cover a portion of that seller responsibility in the blue. And then in the yellow, you'll see this is typically the retention. This is, in this example, it's showing a split retention example. So the seller has kept 0.5% and the buyer has kept 0.5%. This is what we would call a low indemnity deal. So the sellers still have a little bit of risk for the indemnification obligations, but it's much more limited than in a situation where you didn't have RWI. Because the market has been so hot in the women's health space, we are often also seeing this yellow block be non-existent so that it is fully the buyer's responsibility for the deductible or the retention, and then we would consider it to be a no indemnity deal after the closing. The seller would have no ongoing responsibility, very similar to a public style transaction. So with that, Erin will go through some of the regulatory and diligence considerations, and then I'll jump in with some examples.
Great. So a target's compliance with federal and state fraud and abuse statutes and regulations will be a major part of the due diligence review in any transaction in the women's health space. So any relationship with a referral source that includes owners and employees will need to be reviewed to ensure compliance. And so on this slide, we include some key internal diligence topics, but Kayla will discuss kind of in specific the protections in that area as we progress. This slide also mentions a billing and coding audit. So billing and coding compliance is a very important aspect of diligence in any deal, especially in the women's health space, from both a financial diligence perspective and a healthcare regulatory perspective. So to the extent it is determined that there are any routine billing and coding errors, it will be important for a buyer to determine the financial impact of cleaning up those errors post-closing. Legal counsel will likely not be the party conducting this diligence review on the coding practices of the target, but we often see buyers engage a third party to conduct a billing and coding audit on the target. If a buyer seeks to conduct this kind of audit, we recommend engaging the auditor under attorney-client privilege and with counsel. Having counsel engage the auditor on behalf of the buyer is not a perfect shield, but there are ways a buyer can look to protect that billing and coding audit report to mitigate the risk of an external party or the government discovering that audit later on. We typically see parties kind of progress with the billing and coding audit, sometimes even before engaging counsel, and we do want to make sure that that audit can be at least arguably under attorney-client privilege. The next slide references one of the main fraud and abuse statutes that we will look to as healthcare counsel when we diligence. So the two main healthcare fraud and abuse statutes are the Stark Law and the Federal Anti-Kickback Statute. The intent of both statutes generally is to restrict payments for referrals, but both laws are so different. We're going to discuss the Stark Law relatively briefly today because its application to providers in this space is, it really varies. Because fertility clinics do not have government pay other than TRICARE, the Stark Law doesn't apply. And further, if there is a group practice for an OB practice, Stark Law is often less of a concern here because less than 5% of the revenue of the OB practice is likely from Medicare, which triggers a compliance safe harbor under the Stark Law. That being said, even if revenue of the group practice for an OB practice is under 5%, we want to make sure that you know that other financial relationships outside of that group practice still need to comply with the Stark Law. So, for example, arrangements with hospitals. So, call coverage arrangements and other leasing arrangements with hospitals still must comply with Stark. But given that the Stark Law is really not as applicable to this industry, we progress with the federal anti-kickback statute. And unlike the Stark Law, this statute is an intent-based statute. So there must be an intent to induce referrals. And there are certain safe harbors in this statute that we can rely on in terms of protecting arrangements. So if an arrangement fits under the elements of a specific safe harbor, the arrangement is immune from prosecution under this law. And Kayla will discuss next a few specific safe harbors that you may encounter in this specific space.
Great, thanks, Erin. So I wanted to talk a little generally about leases and other agreements with referral sources. So these are by no means exhaustive rules. Each of the particular exceptions under Stark and safe harbors under the anti-kickback statute have numerous elements, and each arrangement needs to be reviewed in detail. But we really have a couple of cardinal rules that, if I've talked to you about this before or one of my colleagues has, you've really heard these time and time again. So the first thing is fair market value. To the extent an arrangement is with a referral source, it nearly always is required to be arm's length and fair market value. There's a couple of ways to assess fair market value. So the first is going out and getting a formal appraisal. That is always the safest approach because it's the most reliable method for assessing fair market value. But sometimes internally at your organization, particularly if you are at a fairly large organization, you do have the opportunity and the resources to pull market and comparable services and determine fair market value internally. That can also often be an acceptable method. We generally recommend making sure that those are well documented and there's no question that the agreement or the payments between the parties are in fact fair market value. The other element is arm's length negotiation. So whether it's a lease, a call coverage agreement, a PSA, a lab arrangement, any entity in which you have a referral relationship, it does not necessarily have to be a physician. It could be a hospital or a lab, for example. It's important that the negotiation is arm's length. So you are not, for example, providing services in exchange for an understanding that further referrals would come somewhere else in a different area of your business. That's an extreme example, of course, but that's one way in which arm's length negotiation is often assessed. The next is a pure purpose. So under the anti-kickback statute, from an intent-based perspective, not one purpose of the arrangement can be to reward or otherwise induce any governmental business. And I'll take this one actually a step further because in the fertility business, obviously there is not much that's government pay, but almost every state in the entire country has either what we call a baby Stark Law, which is a state level version of the federal Stark Law, or a baby anti-kickback statute, a state level version of the anti-kickback statute that applies broader than just Medicare or Medicaid. It often will also apply to commercial payers, and then sometimes it can even apply to cash pay. So very important that intent is not to induce or otherwise reward referrals in order to make sure you're not running afoul with either the federal or the state fraud and abuse laws. And then the last is documentation of intent and documenting the service. Very significant number of exceptions under the Stark Law and safe harbors under the federal anti-kickback statute require a written agreement that lays out the key terms that's been signed by all parties. So whether or not that's required from a fraud and abuse perspective or not, it is very good practice to ensure that that's always the case. And that is when you're going through the diligence process, making sure that the target entity has done that in the past. And then also, if you are operating a business now or looking to go to market in the future, making sure that you've implemented that as well. Another safe harbor we often get questions about from a federal anti-kickback statute perspective is the employment safe harbor. And it's very important to remember that this safe harbor and the referral relationship does not only apply to physicians. Often businesses rely on this safe harbor for purposes of physician compensation under the anti-kickback statute, but also compensation for people like marketing personnel or maybe your schedulers, if to the extent that you're utilizing some type of bonus for them calling patients. All of this is still important, even if you're compensating people outside of the physician category. So first, cardinal rule here, bona fide employment relationship. In order for this safe harbor to apply, you always have to have a bona fide employee. It will not apply to independent contractors, for example. And how you assess that is typically viewed as the IRS standard for common law employment. So when you're looking at whether or not this applies, you should look at all of the same elements that you look at to determine whether or not the person is a common law employee. The other element and an often misconception about this safe harbor is it applies to services that the employee renders. So if you're paying the employee for services that that employee renders, it can apply. It does not, and has been said by many different commentary by different governmental agencies, apply payments explicitly for referrals. So just make sure you're aware of that as you're looking to apply the safe harbor. The next is space and equipment leases. Nearly all of your organizations will have to address these leases. Sometimes they will be with referral sources such as hospitals, other physician groups. Sometimes you may even sublease. For example, OBs often sublease to maternal fetal medicine doctors. Be aware of that. But you will need to assess whether or not the federal anti-kickback statute will apply in that situation. So if it does, and you do have a lease with a referral source, making sure that it is fair market value, it's following those core rules that we talked about. And then here for your reference in the future, we've also listed the other elements of the safe harbor that you should recognize and ensure are met. The next are medical director agreement and personal services contracts. We see this most commonly in OBGYN businesses. These almost always come into play for call coverage agreements because they're often with hospitals. To the extent you have PSA or other laborious services, these are going to come into play. And we often see hospitals moving toward co-management with OBGYN groups to manage certain elements of their hospital, particularly on the OB side. So there's a lot of crossover risk in this situation for both the Stark Law and the federal anti-kickback statute because you will have to meet an applicable exception. I won't spend a lot of time talking about this because it's very similar to other referral source arrangements. But again, it's always important that it's fair market value. To the extent that you're contracting with a hospital, they often will encourage formal valuations, which we believe is generally good practice. We've listed here the other elements of the anti-kickback statute safe harbor that will be specifically applicable to these call agreements, PSAs, and co-management agreements. And another element that I've often seen be problematic for my clients are timesheets. So to the extent there is an hourly requirement under your call agreements with a hospital or under a PSA with a hospital, we recommend good timesheets and ensuring there's good record keeping. And this would go for anytime you're diligencing a business as well, because it demonstrates that as a group, you were in fact providing the services that were called to be provided under the agreement. So that becomes very important. The next item is the Federal False Claims Act. So the number one question that we often get around compliance with the federal Stark law and compliance with the federal anti-kickback statute is what happens if for some reason we don't comply. That's where the Federal False Claims Act comes into play. The Federal False Claims Act is not only applicable when you violate the Anti-Kickback Statute or Stark. You'll see here there's many other situations in which it applies, but FCA actions can be based on violations of the Anti-Kickback Statute or on violations of Stark. So this is something that people often look to if there is a violation. It's something you should be aware of if you're going through diligence and realize there is a Stark or a kickback potential violation, because this will outline some of the penalties. And here you'll see we've listed penalties are often not less than $500 here, $5,500, not more than $1,000 per claim, but there's also this ability for treble damages. So you'll see that that can often be very significant, and people are often very worried about that from a Federal False Claims Act perspective. And then the next slide is just a little bit on what I was discussing earlier about state level fraud and abuse laws. So there almost always, in every state across the country, is some version of the federal Anti-Kickback Statute and the federal Stark law. And it often can be broader, it often can be different. So for example, the federal Stark law applies to both ownership and compensation relationships, whereas some state laws apply only to ownership. In other situations, the way in which the state law defines designated health services under their baby Stark law will be different than the way that the federal law defines designated health services. So anytime that you're looking at an arrangement, whether it be through diligence or whether it be through general operation, you need to be aware that you need to look at both the federal law and the state law to ensure it complies. And then the second bullet is just to make you aware of a different type of law, which we call fee splitting laws. So to the extent that you have a relationship, either contractual in the form of something such as a management relationship, or you have a relationship with other physicians, there will often be restrictions on how you can split professional fees with individuals who are not within your single group practice. Every state is very different. States like New York, for example, prohibit percentage-based fees due to their state law fee splitting restrictions. And this is going to be a very case-by-case analysis. We just flag it here to ensure you're aware that these exist, so you can look at them in the connection with the diligence process and then also in connection with ongoing operations. And with that, Erin's going to talk a little bit about HIPAA.
Thanks, Kayla. So the next area of diligence that we often see as one of the big buckets is HIPAA. Of course, there's the federal privacy and security laws and regulations, but we also have to consider state law privacy and security laws and regulations as well. In terms of HIPAA, I'll discuss the specific things that we look for when we are diligencing a target in connection with its compliance with HIPAA. But in addition to not only reviewing the target's compliance with HIPAA, it's important that the parties comply with HIPAA during the transaction process. So, for example, protected health information such as patient names or anything related to that PHI should be redacted from diligence documents. And so we would often see when people upload AR reports or perhaps complaints that patients have made, we want to ensure that the patient's PHI is redacted from those documents. In addition, there are specific HIPAA considerations that need to be considered in connection with egg donation, egg storage, and tissue storage. We always recommend a fulsome consent process in connection with releasing information regarding egg freezing, egg donation, and tissue storage to family members and any other individual who is not the donor. So this is one specific area unique to the women's health industry that Council will be reviewing in its diligence review to ensure compliance. The buyer will be looking to see if the seller has a robust HIPAA compliance program. So that means a little more than just having stock HIPAA policies and procedures. The buyer will want to determine if the target has more precise or tailored policies and procedures. They'll be looking to see if the target conducts security risk assessments and whether the target trains staff at hire and on an annual basis thereafter. Also, we will also look to see if they have a notice of privacy practices. Are those NPPs given to patients, every patient? Is it also uploaded to the website? There are definitely things under HIPAA that the diligence review will encompass, and this is something that counsel can review prior to a transaction starting to ensure that the target has at least some fulsome compliance measures in place with respect to HIPAA before a buyer's diligence proceeds. Another area is compliance plans. So the buyer will also need to determine if the seller has a compliance program that complies and satisfies the OIG 7 elements of an effective compliance program. In light of the COVID-19 pandemic, providers will also need to ensure they comply with certain laws and regulations, as well as terms and conditions associated with any funding they received during the COVID-19 pandemic. And Kayla will discuss those specific considerations next. But in terms of a general compliance program, if there's a small organization, compliance is not necessarily recommended. But as Kayla mentioned in the beginning, organizations that do not have an effective compliance program definitely ensure some risk that compliance has not been met. And effectuating and implementing an effective compliance plan is always the preferred approach here.
Great, thanks, Erin. And before we talk about COVID-specific considerations, we've received a couple of questions that I just wanted to address briefly that speak to topic areas we've already discussed. So there was a question about what percentage of TRICARE revenues for a fertility practice might trigger a Stark review. So in the most recent commentary by CMS was fairly clear that the only payer that is covered by Stark compliance is Medicare. And so most attorneys do not believe that TRICARE triggers the federal Stark law. However, it will absolutely trigger the federal Anti-Kickback Statute, and it often will trigger state law provisions that may be similar to the federal Stark law. So I just wanted to be aware that was a question that had been asked on some of the fraud and abuse topics that were just discussed. So with that, let's go through the COVID-specific considerations. Everyone in their businesses has dealt with COVID a little differently. And it is definitely informing transactions that are happening today, especially in the wake of COVID, and we expect it will continue to affect them within probably the next several months, but likely the next year. So businesses recovering from financial losses often present unique challenges in the transaction context. First, it can make the Q of E's difficult to decipher and expound on for future growth. It also has driven people to consider earnouts more closely than they had in the past. Earnouts are a very complex topic. They often implicate a significant number of fraud and abuse laws, both at the federal and the state level. So to the extent that your business is considering the use of an earnout, I would encourage you to speak specifically with your counsel on each of the individual topics before implementing it. The next thing on transaction structuring in connection with COVID, I've seen many buyers prefer asset transactions to try to protect against some of that corporate level risk. It is not across the board a position that I've seen everyone take, but they have been becoming more common than they were prior to COVID. I also see bifurcated sign and closes happening more frequently now than prior to COVID. And a large reason for that is some of the backlog that has been happening at the regulatory agencies. It's often been difficult to ensure that all the licensure approvals and other approvals that are required by payers, for example, are happening timely, and that's caused many individual sellers and buyers to seek bifurcated sign and closes where they previously signed and closed on the same day. I mentioned this at the beginning of the discussion, but third-party consents and approvals have been delayed in many scenarios. For individuals that have large transactions pending, I've mentioned this at the beginning of the call, the FTC recently issued a position that they may issue to specific companies what they've been calling close at your own risk letters. which means that they have not completed their analysis by the time that the 30-day window has closed for antitrust review, they may issue you a letter that says essentially close at your own risk. That doesn't change the legal requirements on the FTC for reviewing particular transactions, but it has been injecting some additional uncertainty into the market and how buyers and sellers respond to those type of letters. We talked about RWI in detail because the market has been so hot in a variety of different healthcare areas. We are seeing RWI reviews and diligence to be slower than it is normally, just because it's taking people longer time to process the information because just bandwidth concerns in connection with COVID and then also in connection with just deal volume generally. So that's something to be aware of as you're planning your transaction timing. Those could be things that delay the transaction. The next is employment considerations. Many of you on this call are likely grappling with vaccines for staff. How do you approach it at the company? How does a potential target company approach that? Are they mandated? Are they not? Did the mandate result in employees leaving the company and therefore vacancies in the workforce? All of those things are something to consider whenever you're diligencing a company, but many of you are probably also dealing with it with your own companies. So just that's something that's definitely COVID specific. There's also a significant number of leave and alternative work considerations that have come up in COVID. The back to work plans for many people have not been fully implemented yet, and there's often some incongruencies between target entities that are being acquired and then the opinion of the buyer on these type of issues. So it's important to talk through those, and they're definitely things that are unique in this COVID era. The next is telehealth and compliance regarding HIPAA and other telehealth issues. Telehealth was used prolifically during COVID, and many patients really liked it. So we've seen an increase in the number of requests and expansion of telehealth programs and ensuring that the ways in which the telehealth platforms are working comply with HIPAA and then are also very user-friendly. So anytime you're implementing a new telehealth program, we strongly advise that you talk with your counsel about them because every state has slightly different telehealth programs and telehealth laws. And so if you're, for example, acquiring a new business in which you're planning to implement your current telehealth platform, but they're in a new state, it's important to look at whether or not that is permitted under the state laws or if there's any particular wrinkles or waivers that you're required to obtain. And then the last is vendor considerations. So we've seen a prolific number of force majeure provisions being relied on in order for both vendors to cancel supplies and then also for practices to reject supplies or other services. So it's just something to be aware of if there's ever been any of those instances in a target practice, if you're a buyer or if you're operating a business, any of that has happened, being prepared to answer questions about it is very, very important. Other COVID considerations. So when you're diligencing a business, particularly their compensation, we recommend obtaining lists of all furloughed, reduced pay, reduced schedule employees so that you understand, were they brought back up to prior levels after COVID normalized a little bit, or are they still on reduced pay? Just understanding that from a financial perspective is important. And then to the extent there were any accelerations of payments to employees, either after COVID normalizations or before, making sure those are understood as well. We have noticed in our diligence process, there's been significant amounts of employee feedback related to COVID, and there's a lot of employee engagement that we've experienced. So understanding that during the diligence process as a buyer is very important. To the extent that there is any claims for failure to provide a safe work environment, for example, there could be ongoing litigation or claims from that. That could be a risk point that you want to understand, particularly if you're going to be operating the business on a post-closing basis. And then the other element is compliance with governmental relief. There's three main situations in which people have received governmental relief. So first is the Paycheck Protection Program. Many of you are well aware of PPP loans. Many of them at this point have been forgiven, but to the extent that they have not been forgiven and you're going through a transaction process, there's some very specific ways in which you should escrow the funds to ensure forgiveness is not jeopardized. That's something that we've been working with a lot of our clients on to ensure it's properly done. And the other main program that people receive funds for are HHS provider relief funds. Those are the funds that came in a number of different tranches. For many practices, you often receive those even without requesting them, at least in the first tranche. And there are some very specific attestations and reporting requirements for you to follow in the event that you did not return the funds to the government. And so really understanding with your operations team and likely in many situations your outside counsel how to deal with those and how to report on those is very important. To the extent that anybody has questions related to that reporting, there is on the McGuireWoods website a repository of articles that we have written on some of the specific reporting requirements and the specific FAQs that have come out. This is under the COVID relief portion of the McGuireWoods website. So please do feel free to reference those if that's ever helpful, because the reporting is ongoing and is fairly work intensive for both companies that are operating today, and then also to the extent that you're buying another company, you're going to want to make sure that you understand all of the data that they've kept with respect to HHS provider relief funds to ensure you can assist them in that reporting process on a post-closing basis. And then last, here are just some specific vendor considerations. I won't go through these in detail because I think that many people on this call have addressed these in detail during COVID. But they're here for your reference in the future. If you have any questions on these, we're happy to discuss them further. But thank you, everybody, for joining us. We've had a couple of different questions that have come through during the presentation. To the extent that we have not answered your question during the presentation, we'll reach out and try to answer it after the fact. Again, Erin and I really appreciate you joining us. Please, at any time, feel free to shoot us an email or a note if you're thinking about a potential opportunity or if you're thinking about a particular issue that's arisen in the women's health or the fertility field. We're happy to be a resource and share any information that we have. But with that, we will sign off, and thank you so much for everyone joining us. We've enjoyed it.